have your stuff to study. I knew that.
I'm doing it now. Right. Substantive due process. Introduction. Substantive due process guarantees that laws will be reasonable and not arbitrary. Substantive due process derives from the Due Process Clause of the Fifth Amendment, which applies to the federal government, and the Due Process Clause of the 14th Amendment. Which applies to state and local governments. The same tests are applied under each clause. Applicable standards. When a fundamental right is limited, the law or action is evaluated under strict scrutiny standard. In all other cases, the rational basis standard generally applies. For example, in cases involving economic rights, the right to education, and the right to physician-assisted suicide. Fundamental rights include all First Amendment rights, the right to interstate travel, privacy-related rights, and voting. Note, fundamental rights can be enumerated in the Constitution or unenumerated. Right? What? Whether an unenumerated right is, or unenumerated. Whether an unenumerated right is fundamental depends on whether it is deeply rooted in the nation's history and tradition and essential to the concept of ordered liberty. Relationship between substantive due process and equal protection. Both substantive due process and equal protection guarantees require the court to review the substance of a law rather than the procedures employed. Substantive due process. If a law limits the rights of all persons to engage in some activity on the NBE, it usually is due process question. Equal protection. We scored again. It's 41-14 now.
Oh, 41. Nice.
It must have been a fun game to watch.
It totally sounds like we're following fantasy football.
History and tradition. Okay, so I'm just going to read substantive due process one more time. If the law limits the rights of all persons to engage in some activity on the NBE, it is a due process question. Like, I don't understand why they're telling me about the NBE. So let's just take that out of the sentence. NBE has nothing to do with substantive due process. If the law limits the rights of all persons to engage in some activity, that's the definition of due process. A law or substantive due process is affected by laws that limit the rights of all persons to engage in some activity. Let's not make this like too hard. Equal protection, on the other hand, is affected by laws that treat a person or class of person differently than others. It's like just take the NBA out of it. What the hell is it? And then there's these essay tips. I don't need the tips right now. I can read them to myself, but Class of 1. The Supreme Court has recognized, at least in relation to property regulation, that an equal protection claim can be brought by not only for discrimination against a group, but also for arbitrary treatment of a single individual, a class of 1. However, the court has held that an at-will government employee who claims to be the victim of arbitrary discrimination cannot use the class of 1 theory to make an equal protection claim. I've literally never, ever, I did not read anything about that. And it's such a waste to talk about right now. Privacy-related rights. Various privacy rights include marriage, procreation, contraception, and child rearing regulations substantially burdening these rights are reviewed under the strict scrutiny standard. So the reason why everything's terrible. Okay. Marriage. A law prohibiting a class of adults from marrying is likely to be invalidated because unless the government can demonstrate that the law is narrowly tailored to promote a compelling or at least important interest. Ban on interracial marriage triggers and fails strict scrutiny. Same-sex marriage, the fundamental liberties guaranteed by the 14th Amendment, and this is current as of right now. Where are we? December 2022. Necessary, narrowly tailored. The fundamental liberties guaranteed by the 14th Amendment, both the due process and equal protection clause, require every state to issue marriage licenses to two people of the same sex and recognize same-sex marriages performed elsewhere. Bans on same-sex marriage are not based on any legitimate interest related to protecting or promoting marriage. Special test in prisoners' rights cases. A statute restricting the rights of prison inmates to marry will be upheld if reasonably related to legitimate penological interests. Minimum age requirements. Regulations that don't substantially burden the right to marry, such as minimum age requirements, are subject to rational basis review. Procreation. Individuals have a fundamental right to reproduce that cannot be limited by any state. And they're talking about sterilizing repeat offenders of crimes of moral turpitude. Use of contraceptives. A state cannot prohibit the distribution of non-medical contraceptives to adults or minors. Rights of parents. Parental rights are fundamental rights. They include the companionship, care, custody, and upbringing of children. States cannot require public school education or education in English. Parents have a fundamental right to forbid visitation by a child to grandparents. Keeping extended family together. There's a fundamental right for family members, even extended to ones, to live together. However, this right does not extend to unrelated people. Abortion. The Supreme Court recently overruled a line of cases that held that the Constitution protected a woman's right to obtain an abortion, as there is no longer a fundamental right, as there never should have been, to an abortion under the federal Constitution. The matter is left to the states to legislate. The court has stated, though, that laws restricting abortions are entitled to a strong presumption of validity when they're restricting abortions under a rational basis review. Further, the court has identified several legitimate state interests that can support a restriction, namely respecting and preserving prenatal life at all stages of development, protecting maternal health and safety, eliminating particularly gruesome and barbaric medical procedures, preserving the integrity of the medical profession, mitigating fetal pain, and preventing discrimination based on race, gender, and disability. Obscene reading material. The right to privacy includes freedom to read obscene material in one's home except for child pornography, and not the rights to sell, purchase, or transport such material. Collection and distribution of personal data, no privacy right. The state may reasonably gather and distribute information about its citizens. Thus, there is no privacy right to prohibit the accumulation of names and addresses of patients for whom dangerous drugs are prescribed. The right to travel, interstate travel. An individual has a fundamental right to travel from state to state and to be treated equally after moving into a new state. Note, though, that not every restriction on the right to cross state lines is an impairment of the right to travel. For instance, tolls would not be invalid. Well, tolls just to enter and leave a state would be invalid, but if they're for the state roads, that's fine. Increased penalties for a parent abandoning their children and leaving the state are valid. Right to equal treatment in a new state. A problem arises when a state imposes a minimum duration of residency requirement for receiving its benefits or otherwise dispenses state benefits based on the length of time a person has resided in the state. It isn't clear whether the court always reviews these regulations under the strict scrutiny standard Oh my God, we seriously just got 3 more points. No, we just scored again. It's 48-14.
The record's gonna be 12-1 after this.
God, poor New York. They just can't stop getting beaten by us. That's just.
I don't know if
sad.
that's totally true. I wouldn't feel
Yeah,
bad for them for that reason.
Okay, but like in New York, wait, yeah.
No, I just
Our
think
record against New York is like we've lost there once.
they always like we lost to them in the beginning of the season. Not the beginning of this season, but the last one. It's like it was always a tie. It was always, it's always an overtime. It's just stressful.
I think I
feel bad for New York because they can be as good as they should be, but they don't play up to it. Like
1-year residency to receive full welfare benefits is invalid. 1-year residency to receive state subsidized medical care is invalid. 1-year residency to vote is invalid. However, 30-day residency to vote is valid, and 1-year residency to get divorced is valid. So basically consider everything invalid unless it's like 30 days. Which I think is crazy because I have read in previous places that making sure that you're getting the identity of the voter right for these new people that recently moved to the state is a legitimate enough interest to have a waiting period of a year. But here it's 30 days and a year is invalid. Right to international travel. International travel is not a fundamental right. It is, however, protected from arbitrary federal interference by the Fifth Amendment due process clause. The rational basis standard applies. Right to vote. The right to vote is a fundamental right. As a result, restrictions on that right, other than on the basis of residence, age, and citizenship, are invalid unless they can pass strict scrutiny. Restrictions on right to vote, property ownership, residency requirements, identification, poll taxes, and primary elections. So for primary elections, states can require early registration to vote in primaries. However, states can't prohibit political parties from opening their primary elections to anyone, whether or not registered with the party. Interesting, trying to compare that to how I'm not allowed to vote in primaries if I'm in Pennsylvania and registered with the opposite party, or not registered with the primary party. So the state can so the states can't prohibit political parties from opening their primary elections to anyone. The state can't prevent the party from opening their elections to anyone. But they do in Pennsylvania when Obama's running against Hillary Clinton. Anyway, dilution, that's going back a ways, so maybe that changed. Identification. A state may require voters to show government ID. Poll taxes are unconstitutional. Residency requirements of a reasonable time, example 30 days, are valid. Note that Congress can override state residency requirements in federal elections and substitute its own. Property ownership. Conditioning the right to vote or hold office on ownership of property is usually invalid. Special purpose elections, for example, water storage districts, are the exceptions. So, dilution of the right to vote, one person, one vote principle. The one person, one vote principle applies whenever any level of government decides to select representatives to a governmental body by popular election from individual districts. State and local elections. For state and local elections, the populations of voting districts must be substantially equal. That is, the variance in the number of persons included within districts can't be unjustifiably large, but the districts don't need to be within a few percentage points of each other. A state must show that a deviation from mathematical equality is reasonable and tailored to promote a legitimate state interest. For example, preserving political subdivisions, although a 10% variance is presumably valid. The court upheld a 16% variance as reasonable in light of the state's interest in preserving political subdivisions in communities and in light of geographic factors. But they got to be substantially equal within 3, 12, or 16%. So, congressional elections. States must use almost exact mathematical equality when creating congressional districts within the state. Even a 0.7% variance was invalidated. This isn't true, however, when Congress apportions representatives among the states. Congress's good faith method for apportioning representatives gets more deference and is not subject to a precise mathematical formula as the state plans. Districts can be measured using total population. When states measure the equality of their districts, they don't have to count only persons eligible to vote. Counting the total population is sufficient, and this best serves the one person, one vote principle. Exception: appointed officials and officials elected at large. The apportionment requirement is inapplicable to officials who are appointed or elected at large. Exception: special purpose election. One person, one vote principle doesn't apply to elections of officials who do not exercise normal governmental authority, but rather deal with matters of special interest in the community, such as water storage districts again. Gerrymandering. Race and presumably other suspect classifications cannot be the predominant factor in drawing the boundaries of voting districts unless the district plan can satisfy strict scrutiny. Compare that to political gerrymandering, that is, drawing district lines to achieve certain political results, which sometimes results in districts with the contours of a mythical salamander. Which is a non-justiciable political question.
Does that really say that?
It says that.
Does that not mean anything else?
It says that drawing district lines to achieve certain political results, which sometimes results in districts with the contours of a mythical salamander, is political gerrymandering and a non-justiciable political question.
Sounds like gerrymandering.
Yeah, gerrymandering. States may use independent commissions to draw districts. To avoid gerrymandering, states can use independent commissions to adopt congressional districts, rather than allowing the state legislature to redistrict. All right. Candidates and campaigns. Candidate qualifications. Fee must not preclude indigence. States can't charge candidates a fee that makes it impossible for indigents to run for office. Restrictions on ability to be a candidate. A ballot access regulation must be reasonable, non-discriminatory means of promoting important state interests. A state may require candidates to show reasonable support to have their names placed on the ballot. Campaign funding. The government can allocate more public funds to the two major parties than to minor parties for political campaigns. Campaign funding. The government can allocate more public funds to the two major parties than to minor parties for political campaigns. That could happen. Right to bear arms. It's like every time I read more constitutional law, they're making stuff up. The Second Amendment protects the right of individuals to bear arms or self-defense. This includes the right to keep a handgun at home and the right to carry a handgun in public. Right to bear arms, right to self-defense. So I just read that. Standard of review. If a regulation burdens an individual's right to keep and bear arms, then the government must justify the regulation by demonstrating it is consistent with the country's historical tradition of firearm legislation. The historical inquiry should pay particular attention to evidence from the Second Amendment and the 14th Amendment, where adopted, that is respectively 1791 and 1868, simply positing that the regulation promotes an important interest is not sufficient. Examples: bans on firearms in sensitive places, such as legislatures, courtrooms, and schools, are constitutional based on historical tradition, and there is no analogous historical tradition to justify general bans on handguns in the home or in public. Standard of review. If a regulation burdens an individual's right to keep and bear arms, then the government must justify the regulation by demonstrating it is consistent with right to fair notice. Fundamental principle of our legal system is that laws can regulate people or entities must give fair notice of conduct that is forbidden or required. A regulation that fails to give fair notice violates the due process clause. Unspecified rights. Intimate sexual conduct. A state has no legitimate interest in making it a crime or for fully consenting adults to engage in private, intimate sexual conduct, for example, sodomy. That is not commercial in nature. While the court has not stated what standard of review should be applied to such laws, it has indicated that they can't even pass the rational basis test because of a lack of a legitimate state interest. The Supreme Court struck down a criminal ban on same-sex intimate conduct, in Texas. Right to refuse medical treatment. The right of a mentally incompetent adult to refuse medical treatment mentally competent, is a part of an individual's liberty under the 5th and 14th Amendment due process clauses. However, the Supreme Court has not ruled that this aspect of liberty is a fundamental right and has not explained which standard of review should be used. Compare no right to assisted suicide. There is no fundamental right to physician-assisted suicide. And compare compelled vaccinations. States can compel vaccination against contagious diseases. Rural activity, blah, blah, blah. I totally don't care about these 2 adult males in a tent in a state park. Park ranger. I'm trying to enforce the century-old anti-sodomy statute. Okay, are these questions? This is trying to be a question. Okay, so we got to equal protection on page 63. I have 43 more pages to read. But this does sound an awful lot like the reading from earlier today. So I think the most important part to read is probably freedom of speech, freedom of religion, and the Establishment Clause isn't so bad. This equal protection section is really not hard at all. Takings clause. Okay. So we keep going, maybe just past the takings clause. So with equal protection, introducing the topic, it doesn't take long to get to the takings clause. An equal protection claim arises whenever the government treats people differently from others. The equal protection clause is the 14th of the 14th Amendment is limited to state action, where the Equal Protection Clause is not applicable to the federal government. The Due Process Clause of the Fifth Amendment contains an equal protection component. Thus, there are really two equal protection guarantees. Applicable standards. If a fundamental right or suspect classification, for example, race, is involved, the strict scrutiny standard is used to evaluate the regulation. If a quasi-suspect classification is involved, for example, gender, intermediate scrutiny is the applicable standard. If the classification does not affect a fundamental right or involve a suspect or quasi-suspect classification, the rational basis standard applies. Now, proving discriminatory classification for strict or intermediate scrutiny to be applied, there must be intent on the part of the government to discriminate. Intent may be shown by a law that is discriminatory on its face, that is facial discrimination, overt discrimination as we call it in banking, a discriminatory application of a facially neutral law, which is called disparate impact, and, well, disparate treatment, because the next down is a facially neutral law with a disparate impact on a protected class of people, such as minorities. So, note the second and third ways to show intentional discrimination and discriminatory intent are the most difficult to prove. A discriminatory intent or effect alone is not enough. The legislature's discriminatory intent must be shown, for example, by evidence of a history of discrimination. Examples: facial gender classification, a law that expressly taxes income of women at a higher rate than men. Example 2, non-facial gender classification, a law that taxes the income of shorter individuals at a higher rate, and emails show the purpose is to discriminate against women. A couple hypos, talking about police officers, talking about veterans. Most of them are men. Police officer standards sometimes do negatively affect women. Okay, so those are your two examples. What standard applies? Intermediate. Strict scrutiny. Right? These hypos don't even answer themselves. I'm skipping them. Suspect classification. Classifications are suspect if they are based on race, national origin, or at the state and local level, alienage. Race and national origin. Classifications based on race or national origin are judged by a strict scrutiny standard. Race, national origin. Not in there did we say non-resident aliens. School integration. Intentional segregation violates the Constitution. If school systems and attendance zones are established in a racially neutral manner, there is no violation. Thus, there is no violation if housing patterns result in racial imbalance in schools. Remedying intentional school segregation. If it's proven that a school board has enacted in the racial districting of schools, the board must take steps to eliminate the effects of that discrimination, for example, busing students, if the school refuses to do so, to eliminate the discrimination, but the order cannot go beyond the purpose of remedying the past effects of segregation. Compare promoting diversity in primary and secondary schools. The Supreme Court has found that assigning students to a primary or secondary school on the basis of race solely to promote diversity, as opposed to remedying past intentional segregation, does not satisfy strict scrutiny. So it has to be a particular school district that back in the 70s had one of these, like, I don't know, Johnson or some presidential, like, order to spend the next 20 to 30 years correcting past intentional segregation. It's not one of those school districts, and it's not doing specifically that, then it probably will fill a strict scrutiny standard if your school community and acceptance measures in a public primary or secondary school are solely on the base of race and promoting diversity. In colleges, higher university, it's different. We're going to get to that in this whole separate section titled Affirmative Action, Benign Government Discrimination. Government discrimination, whether by federal, state, or local governmental bodies that favors racial or ethnic minorities, is subject to the same strict scrutiny standard as is government action discriminating against racial or ethnic minorities. Remedying past discrimination is the first point. The government has a compelling interest in remedying past governmental discrimination against a racial or ethnic minority. The past discrimination must have been persistent and readily identifiable. A race-based plan cannot be used to remedy general past societal discrimination. I do believe it needs to be kind of like a court-ordered race-based plan. There's several cases about it. Mainly like Cleveland is coming to mind. There was no past discrimination. Where there was no past discrimination, even where the government has engaged in past discrimination, it may have a compelling interest in affirmative action in limited contexts. However, remember that the governmental action must be narrowly tailored to that interest. Diversity in higher education. Unlike the public primary and secondary schools, the Supreme Court has deferred to public colleges and universities that have claimed that they have a compelling interest in having a diverse student body. Thus, the court held that race and ethnicity could be used as a factor, although not a predominant factor, meaning not like the only factor in an individualized assessment for each student for admissions. However, the court will not defer to colleges and universities regarding whether a particular scheme for assuring diversity needs strict scrutiny. The school must show that no workable race-neutral alternatives would assure the diversity sought. These are public colleges and universities. I do not know what an outcome will be at a private university. States may eliminate race-based preferences. States aren't required to have an affirmative action programs for admission to their universities. Moreover, they may eliminate existing race-based preferences, including by voter initiative. Discriminatory legislative apportionment. If a plaintiff can show that a redistricting plan was drawn up predominantly on the basis of racial considerations, strict scrutiny is triggered and the plan will violate the Equal Protection Clause unless the government can show that the plan is narrowly tailored to serve a compelling state interest. Alienage classifications. So when we were talking about suspect classifications and we said race, national origin, or at the state and local levels, alienage. Because the federal government, okay, well, at least they're getting closer to making this more clear. But here's you have federal classifications, which is why they're separate. Because of Congress's plenary power over aliens, federal alienage classifications are not subject to strict scrutiny. Such classifications are valid if they are not arbitrary or unreasonable. But state and local classifications, generally, state and local laws on alienage, that is citizenship status, are suspect classifications subject to strict scrutiny. Examples is the state and local government may not require U.S. citizenship for employment generally, or government benefits or property ownership or admission to the bar. Exception, participation in self-government process. If a law discriminates against alien participation in state government, for example, voting, jury service, elective office, the rational basis standard is applied. Although the rational basis standard is used for state and local laws limiting certain non-elective offices involving important public policy, for example, police officers, probation officers, and primary and secondary school teachers. Now, here's a section on undocumented aliens. Undocumented aliens are not a suspect classification. Thus, the state laws regarding them are subject to rational basis standard. Compare the children of undocumented aliens. Denial of free public education to undocumented alien children has been held to be invalid. Strict scrutiny does not apply, though the Supreme Court has used language in its opinions evoking both rational basis standard and intermediate scrutiny. I also found that the right to education in general is a property interest. It's not a fundamental right. Pick that up from another section. So that's why it's not just, it wouldn't be subject to strict scrutiny even if we were talking American boys and girls. Classifications based on legitimacy and gender are quasi-suspect. Legitimacy and gender. What is intermediate strict scrutiny? The law must be substantially related to an important government purpose. The government bears the burden of showing exceedingly persuasive jurisdiction. That's probably true for strict scrutiny and for intermediate. So the government bears burden. And both of those both of those equal protection and analyses. Gender classifications based on role stereotypes are generally invalid, whereas those designed to remedy past discrimination are more likely to be upheld under intermediate scrutiny. All these hypos are just for discussion purposes. They're not giving me an actual determination. So here's your classification. Gender-based death benefits are invalid. Gender-based peremptory strikes are invalid. Alimony for women only is invalid. Discriminatory minimum drinking age is invalid when women at 18, men at 21. Discriminatory statutory rape laws, invalid. All-male draft. Discriminatory statutory rape laws are valid. The justification for that is that women can get pregnant, or girls can get pregnant, and men can't. And that is why statutory rape is treated a bit differently among the genders. All-male draft is valid. Don't have a justification for that. And that I know of. And requiring American fathers but not mothers to prove their parentage of non-marital children born abroad in order to obtain U.S. citizenship for them is valid. The reason is that it's easier for a woman to prove their issue than men. So just naturally, that's why it's valid. Marital versus non-marital classifications of children. Again, this is strict scrutiny. This is the, quote, legitimacy part of class that's protected by intermediate scrutiny. Gender and legitimacy. Other classifications are protected on a rational basis, including age, disability, wealth, indigency. It says right here, for example, mandatory retirement age can be established, and because education is not a fundamental right, again, there is no denial of equal protection when wealthier children can afford to pay for access to the best state-operated schools. Animus, not rational. If the government's only interest in denying a benefit to or imposing a burden on a group of people is a dislike for them, the classification will not meet the rational basis reviews. There must be a legitimate governmental interest. Animus would break you would cause a rational basis test to fail, but generally not much else will, as long as a legitimate governmental interest can be cited and it's not the government's burden to prove. Now, examples: the Supreme Court struck down a state law denying discrimination protection to gays and lesbians. The Supreme Court also struck down as a federal law that refused to recognize same-sex couples who were married under state law as married for purposes under federal law. For the NBE, you must memorize the suspect classifications of race, national origin, sometimes alienage. Gender and legitimacy. What was the others? Age. Indigency. What were the others? Disability. Now, and the fundamental rights, which is interstate travel, privacy, voting, and First Amendment. You need to know which standard applies, is basically what I'm saying. You need to have it memorized. There is a table here on page 70. It lays it all out. Very simple stuff. And then we can go into the takings clause. The Fifth Amendment provides that private property may only be taken for public use and the government must pay just compensation. This rule is applicable to the states via the 14th Amendment. Note that the takings clause is not a source of power for taking, but rather is a limitation. Covered property. Property subject to the takings clause includes personal property, real property, and certain intangibles, for example, interest in attorney trust accounts, IOLTAs, and trade secrets, but not welfare benefits. Covered property. Such property, we'll talk about that, is or taking. The critical issue is whether a governmental action is taking, requiring payment of just compensation, or merely a regulation not requiring compensation. There is no clear-cut formula for making this determination, but the following general guidelines are what you should remember. Confiscation or occupation are physical takings. A taking can be found if there is a confiscation of a personal property or the permanent or regular physical occupation of a person's property by a government, for example, by running power lines through your airspace. Or that wasn't even good enough. I feel like it's like bolting a wire to your building. Temporary occupations by the government may also be a taking, depending on factors like the degree of invasion, the duration, and the government's intention, the foreseeability of the result, the character of the property, and the interference with the use of the property. Example, Tahoe had a hold on building near their body of water for a short time, but not forever. That I don't believe is a taking, because they're looking at factors like the degree of the invasion, the duration, the government's intention, foreseeability of the result, and character of the property, and the interference with the use of the property. Then you have exceptions, development exceptions. Municipalities often attempt to condition building or development permits on the landowners, one, conveying land to part of the property to the government, for example, to be used as streets, or 2, granting the public an easement to access the property. Those conditions constitute taking unless the government can show there is an essential nexus between the condition and the proposed development, that is, the condition relates to a legitimate government interest, and 2, the adverse impact of the proposed development is roughly proportional to the loss caused by the property owner from the forced transfer. Emergency exception. Taking is less likely to be found, even for a complete and permanent deprivation, if it's made pursuant to a public emergency such as war. Bunch of unanswered hypotheticals. Use restrictions would get the classification of regulatory taking. The Buccaneers are playing the 49ers right now. Denial of all economic value of land taking. If a government regulation denies a landowner of all economically viable use of their land, for example, a regulation prohibiting any building on the land, the regulation amounts to a taking unless principles of nuisance or property law make the use prohibitable. Temporary denials of all economic use. Temporarily denying an owner of all economic use of property does not constitute a per se taking. Instead, the court will carefully examine and weigh all the relevant circumstances, the planner's good faith, the reasonable expectations of the owners, the length of the delay's actual effect on the value of the property, and so on, to determine whether fairness and justice require just compensation. One of these had to do with probably one of the Carolinas. There was a case about building on beachfront property. Right after he bought it, I think they made that new ruling. So the timing, like, did you own the property before the law changed or after? Because if you bought it after the law changed, then you don't have a right to challenge the use restriction or the developmental use restriction. So, in decreasing economic value, there's a balancing test. Generally, regulations that merely decrease the value of property, for example, prohibiting the most beneficial use, do not amount to a taking if they leave an economically viable use for the property. The courts will consider: 1, the government interest sought to be promoted; 2, the diminution in value to the owner; and 3, whether the regulation substantially interferes with distinct investment-backed expectations of the owner. So the other 2 cases that come to mind is, like, around here in California, there's like some land that's pretty much not able to do anything with it except maybe like mine like clay or whatever is the land is made of. Like excavation. And then when the government says that they can't do that for environmental reasons, then the argument is that they've left that landowner basically no viable use. All economically viable use has been denied. And then the other case that comes to mind is in New York City, when they tried to limit like Penn Central from building like another 12 floors over the 30 or something floors they already had. They wanted to do it anyway and had to basically be enjoined from continuing to build because the restriction did not deny all economically viable use. They could still use it for lots of things. Taking versus regulation. Condemnation of land to build a highway, that's a taking. Creating public access easement on private property, that is a taking. Abolishing inheritance rights, that's a taking. Zoning ordinances that merely prohibit the most beneficial use of property, those are regulations. Ordering destruction of diseased trees, regulation, and landmark ordinances generally are regulations. Public use limitation liberally construed. The government's action is rationally related to a legitimate public purpose, for example, for health, welfare, safety, economic, or aesthetic reasons. The public use requirement is satisfied. Authorized takings by private enterprises are included if they work to the public advantage, for example, railroads and public utilities. One of the questions we saw in the exam was like, they're taking your land so they can expand like a sports facility. And I guess that was a big issue. And I don't know the answer. So that's technically a hypo. But I mean, if they're selling it to a private company, there's your answer. For as part of the city's economic redevelopment plan, that goes the other way because the city's entwined. Just compensation. Just compensation is measured by fair market value at the time of the taking of the property taken at the time of the taking, and it's based on the loss to the owner. Increases in value to the owner's remaining property as a result of the taking is not considered. Just compensation. Just compensation is measured by the fair market value of the property taken at the time of the taking. And it's based on the loss to the owner. Increases in value to the owner's remaining property as a result of the taking are not considered. I read that. Inverse condemnation. When the government acts under the power of eminent domain to take property for public use, it will condemn the property and pay the owner just compensation. When property is taken by occupation or regulation without condemnation proceedings, the landowner can bring an action for inverse condemnation. If the court determines that the government action amounted to a taking, the government will be required to either pay the property owner just compensation for the property or terminate the regulation and pay the owner for damages that occurred while the regulation was in effect. That is a temporary taking damages. Now, retroactive legislation, contract clause, impairment of a contract, ex post facto laws, bills of attainder. This is like 2 pages, so I'll read it quickly. The Contracts Clause limits the ability of state and local governments to enact laws that retroactively impair the contract rights. It doesn't affect contracts not yet made. Not applicable to the federal government. There's no comparable clause applicable to the federal government, but flagrant contract impairment would violate the Fifth Amendment Due Process Clause. Basic impairment rules, private contracts, intermediate scrutiny. Legislation that substantially impairs an existing private contract is invalid unless the legislation serves an important and legitimate public interest and is reasonable and narrowly tailored means of promoting that interest. Public contracts, heightened scrutiny. Legislation that bears, so for private contracts, there's intermediate scrutiny. Legislation that substantially impairs a private contract is invalid unless it serves an important or legitimate public interest and is reasonably and narrowly tailored means of promoting that interest. So, yeah, it's intermediate scrutiny. It's weird. It's like right between, it's right between strict and rational. So thus, intermediate is fine to default for that. There's heightened scrutiny, however, with public contracts. Legislation that impairs a contract to which the state is a party is tested by the same basic test, but the legislation will likely receive heightened scrutiny, especially if the legislation reduces the contractual burdens on the state. Or punishments in a substantially prejudicial manner for the purpose of punishing a person for some past activity. A statute retroactively alters a law in a substantially prejudicial manner if it makes a criminal act that was innocent. I'm sorry, I just skipped right into ex post facto without saying that neither the states nor the federal government may pass an ex post facto law, which means the law that retroactively alters criminal offenses or punishments in a substantially prejudicial manner for the purpose of punishing a person for some past activity. The statute retroactively alters a law in a substantially prejudicial manner if it makes criminal an act that was innocent when done, imposes a greater punishment for an act than it was imposed for when it was done, and reduces the evidence required to convict a person of a crime from what was required when the act was committed. Note that the Due Process Clause of the 5th and 14th Amendments similarly prohibits courts from retroactively interpreting criminal laws in an unexpected and indefensible way. Remember that the ex post facto clauses apply only to criminal cases, so an answer choice that attempts to apply these prohibitions in a civil case is wrong, like the denial of a professional license. Bills of attainder. Bills of attainder are legislative acts that inflict punishment on individuals without a judicial trial. Both federal and local governments are prohibited from passing bills of attainder. So, like, let's just say Osama bin Laden, was an American, then we can't just, go and kill him without having charges and convictions against the guy. Due process considerations. If a retroactive law does not violate the contract, so likewise, you can't say Donald Trump is. You can't just go jump into conclusions. He has to be prosecuted. Can't just name someone as a criminal. And inflict punishment on them without a judicial trial. The Supreme Court struck down as a bill of attainder a federal budget law that denied salary payments to federal employees that Congress determined to be subversive. Due process considerations. If a retroactive law does not violate the contract's ex post facto or bill of attainder clauses, it still must pass muster under the Due Process Clause. If the retroactive law doesn't substantially burden a fundamental right, it only needs to be rationally related to a legitimate government interest. So here's the part about freedom of speech and assembly. And this could take another 27 pages to get through this in religion. The First Amendment prohibits Congress from abridging the freedoms of speech and press or interfering with the right of assembly or from establishing a religion or interfering with the free exercise of religion. These prohibitions are applicable to the states through the 14th Amendment. What is speech? Speech includes words, symbols, and expressive conduct. Expressive conduct is any kind of conduct that is inherently expressive, or conduct that is intended to convey a message and is reasonably likely to be perceived as conveying a message. Is arson speech? Blah, blah. Okay. Intended to convey a message, reasonably likely to be perceived as conveying a message. So words, symbols, expressive conduct are all qualify as speech. If the expressive conduct is inherently expressive, it's intended to convey a message and is reasonably likely to be perceived as a message or as conveying a message. Arson, flag burning, nude dancing, ordinary clothing, black armbands. Unprotected speech, however, lacks First Amendment protection and generally may be censored. Certain categories, such as defamation and commercial speech, only receive partial protection, and other types of speech are protected. All others are. Incitement, fighting words, obscenity, defamatory speech, some commercial speech. So let's take each one. Incitement. Speech can be censored as incitement if it is intended to produce imminent lawless action, and 2 is likely to produce such action. That's all that's being said about incitement here. So just want to make sure that I have that memorized. I have obscenity on this page, but I don't have incitement. Intended to produce eminent lawful action, and 2 is likely to produce. Kind of remember this now. Such action. So it requires intent and likelihood and eminence. It's not like my mom's gonna come back here tomorrow and do da da da. And it has to be likely that she will, and that you want her to. Fighting words. Speech can be censored if it constitutes fighting words personally. Abusive words that are likely to incite immediate physical retaliation in an average person. Words that are merely annoying are not sufficient. So these are personally abusive. Incite, so you incorporate incite into this definition. Immediate, eminence again, physical retaliation. In an average person. True threats, this is how it's divided into true threats, and First Amendment also does not protect true threats, which are words that are intended to convey to someone a serious threat of bodily harm. Actually, might be not a subset. It's a subset of fighting words. Intended to convey to someone a serious threat of bodily harm. Statutes can't be viewpoint based. So even though fighting words aren't protected, the Supreme Court won't allow fighting word statutes that are designed to punish only certain viewpoints. For example, prohibiting only fighting words that insult on the basis of race, religion, or gender. So, viewpoint neutral. To be valid. Obscenity, obscene speech is not protected. What is it? As a whole, by the average person. Right. Okay. So here it says, as a whole, by the average person, appeals to the prurient interest in sex using contemporary community standard is patently offensive under contemporary community standards and lacks serious value, literary, artistic, political, and scientific, using a national reasonable person standard. What I've written is depictions of sexual conduct specified by law that, taken as a whole, all of those things. Appeals to prurient interest, using a contemporary community standard, is patently offensive, has no serious literary value. I'm not sure why politics is here. Political? I mean, the art and science I get. I don't even think I'm going to write down political. Like, that doesn't even make sense. Private possession of obscene material in the home cannot be punished except for the possession of child pornography. However, the protection does not extend outside the home. Child pornography. To protect minors from exploitation, the government may prohibit the sale or distribution of visual depictions of sexual conduct involving minors, even if the material would not be found obscene if it did not involve children. Compare simulated pictures of minors. The government can bar visual material that only appears to depict minors engaged in sexually explicit conduct, but that actually uses young-looking adults or computer-generated images. Obscenity standard may be different for minors. A state can adopt a specific definition of obscenity applying to material sold to minors, even though the material might not be obscene in terms of adult audience. However, the government can't prohibit the sale or distribution of material to adults just because it's inappropriate for children. Land use regulations and liquor regulation. So a land use or zoning regulation may limit the location or size of adult entertainment establishments if the regulation is designed to reduce the secondary effects of such businesses, for example, to protect children and unwilling adults from exposure, or to prohibit neighborhood crime and decay. However, these regulations can't ban such establishments altogether. The Supreme Court upheld a city ban on adult bookstores and theaters within 1,000 feet of neighborhood schools, churches, and parks, which left less than 5% of the city for such speech. Liquor regulation. Under the 21st Amendment, states have broad power to regulate intoxicating beverages. Laws relating to this power that affect free speech rights generally will not be set aside unless they are irrational. When we get to defamatory speech, so all of that land use regulation, liquor, pornography for in the home of children, of simulated pictures of minors, differences between adult and minor, obscenity and obscenity. That was all in the obscene section. How liquor got there, I don't know. But the next section is defamatory speech. We have 14 pages left 24 pages. Defamatory statements can be subject to tort liability if the defamatory statement is about a public official or public figure or involves a matter of public concern. So defamatory statements can be subject to tort liability, period. But if defamatory statements about public officials and public figures involve a matter of public concern, the First Amendment requires the plaintiff to prove all of the elements of defamation plus falsity and some degree of fault in order to recover. Public official or figure suing. If the plaintiff is a public official or figure, then regardless of whether the defamation is on a matter of public or private concern, the degree of fault the plaintiff must show is actual malice. Actual malice, as defined, must be proved by clear and convincing evidence by the plaintiff that the alleged defamatory statement was made with knowledge that it was false or reckless disregard for the truth or falsity. Who were public officials? Holding or running for elective office at any level, public employees in positions of public importance, example, prosecutor, school principal, police officer. Who are public figures? These are people who've assumed roles of prominence in society, achieved pervasive fame and notoriety, or thrust themselves into particular public controversies to influence their resolution. Matters of public concern are issues important to society or democracy. The courts decide on a case-by-case basis whether a defamatory statement involves a matter of public concern, looking at the content, form, and context of the publication. Private figures suing on matter of public concern. If the plaintiff is a private figure and the defamatory statement involves a matter of public concern, the plaintiff can only recover actual damage if the plaintiff only shows negligence. To recover punitive damages or presumed damages, they need to show actual malice. Private figure suing on matter of private concern. If the plaintiff is a private figure suing on a matter of private concern, then the First Amendment is not involved. These plaintiffs can recover for any damages the state allows, even if they can't show actual malice. Because there's no value of the speech. It's not doing the public some service by telling them so-and-so is squandering school board money or something. There's no benefit being gained. It's just an attack. It's a personal attack, like a civil matter. Intentional, so it's not protected speech. Or at least the First Amendment doesn't apply. So you might say that. First Amendment is not involved. You can be punished for that language. Intentional infliction of emotional stress. The Supreme Court has required proof of actual malice for recovery under the torts of intentional infliction of emotional stress and other torts, for example, invasion of the right to privacy, where the plaintiff is a public figure or official, or where the speech is on a matter of public concern. An example is the Supreme Court barred recovery for intentional infliction of emotional distress and other torts against the Westboro Baptist Church for picketing at a fallen soldier's funeral because the plaintiff couldn't show malice. That's awful. Some commercial speech. Commercial speech, that is, advertisements, promotions of products and services, brand marketing, is not protected if it is false, misleading, or about illegal products or services. Any other regulation of commercial speech will be upheld only if it serves a substantial government interest, directly advances that interest, and is narrowly tailored to serve that interest. You can sit there. That. Yeah.
I might have to move when I charge them.
Mm-hmm. Complete bans on truthful advertisement of lawful products are very unlikely to be held due to a lack of legitimate government interest. Narrowly tailored does not require the least restricted means of accomplishing the legislative goal in this context. There just needs to be a reasonable fit between the goal and the means chosen for, directly advancing a substantial government interest. And complete bans on truthful advertisement of lawful products are very unlikely to be held because of a lack of legitimate government interest. Requirement disclosures. The government may require commercial advertisers to make disclosures if the disclosure is not unduly burdensome and they are reasonably related to the state's interest in preventing deception. Ban on those are required disclosures. Commercial advertisers may be forced into that. They're not unduly burdensome and are reasonably related to the state's interest in preventing deception. General speech restrictions. So we enter a new section outside of commercial speech. Content-based regulations are subject to strict scrutiny, and they are presumptively unconstitutional unless they fall within one of the categories of unprotected speech, like obscenity. A regulation is content-based if it restricts speech based on the subject matter, or viewpoint of the speech. Example, a ban on the sale of violent video games to minors is content-based regulation. Content-neutral regulations, on the other hand, content-neutral restrictions on speech, that is, restrictions that are both subject matter neutral and viewpoint neutral, generally are subject to intermediate scrutiny. That is, they must advance important interests unrelated to the suppression of speech and must not burden substantially more speech than necessary, or must be narrowly tailored to further those interests. What do I have here? I have content-based, strict scrutiny, content-neutral, intermediate scrutiny. Limit speech on some other basis. Time out of place, not overbroad, can't burden more speech than necessary to promote government interest. So what it says in this outline is it must advance important interests unrelated to suppression of speech and not burden substantially more speech than necessary. Why am I writing this? Because that's not actually the intermediate scrutiny standard. That's a different standard. That would be substantially related to an important government interest. This says must advance important interests unrelated to suppression of speech and must not burden substantially more speech than necessary. It's kind of the same thing. You could probably get away with saying just the intermediate scrutiny standard when you look at them side by side. But I mean, saying them in two completely different ways does not help anybody. The specific standards for time, place, and manner restrictions on government property are discussed in another section. Oftentimes, these are, the restrictions are in the form of time, place, manner restrictions. In other words, restrictions on the conduct related to speech. So the next section here, we have time, matter, place restrictions. A ban in concerts in the park above a certain decibel level is a content-neutral regulation. Speech restrictions on government property. The extent to which the government may regulate speech or expressive conduct on government property depends on whether the property involved is a public forum, a designated public forum, a limited public forum, or a non-public forum. Traditional public forums and designated public forums. Public property that is government-owned property that it has historically been open to speech-related activities and includes streets, sidewalks, and public parks. These are called public forums. Public property that has not historically been open to speech-related activities, but which the government has thrown open for such activities on a permanent or limited basis by practice or policy. For example, a town hall open for use by social, civic, or recreational groups is called a designated public forum. Levels of scrutiny. If the regulation on a traditional public forum or designated forum is content-based, it will be subject to strict scrutiny. But if it is content neutral, again, both subject matter neutral and viewpoint neutral, usually going to the time, place, or manner of speech, it only needs to meet intermediate scrutiny, which in the context means narrowly tailored to serve an important government interest. However, it need not be the least restrictive means for accomplishing the interest and leave open alternate channels of communication. Note that even if a regulation meets the time, place, and manner restrictions above, it can still be invalid if it is overbroad, vague, or gives unfettered discretion. Injunctions. Injunctions against speech in public forums are treated the same as other speech restrictions. If the injunction is content-based, it must be necessary to achieve a compelling interest. The injunction is content neutral. It must burden no more speech than is necessary to achieve an important government interest. Limited public forums and non-public forums. Speech and assembly can be more broadly regulated in limited public forums and non-public forums. Limited public forums are government forums not historically open generally for speech and assembly, but open for specific speech activity like a school gym, open to host a debate on a particular community issue, or a public university's funding of student publications. Non-public forums are government property not historically open generally for speech and assembly and not held open for specific speech activities such as military bases or government workplaces. The government can regulate speech in such forums to reserve the forum for its intended use. In such locations, regulations are valid if they are viewpoint neutral and reasonably related to a legitimate government purpose if the regulation is viewpoint-based and will be subject to strict scrutiny. So now we're looking at 19 more pages. But you do have speech restrictions in public schools, personal student speech on campus, personal student speech off campus, and school speech. So why? You look at it and see this in the con law book. Why are there these designations? They even convinced me to write one of them down. I don't know why. Generally, public primary and secondary schools, as elementary, middle, and high schools and school-sponsored activities in those schools are not public forums. Therefore, speech and association can be reasonably regulated in them to serve the school's educational mission as illustrated below. Personal student speech on campus. A student's own personal speech, that is, their expression of themselves as individuals on campus, cannot be censored absent evidence of substantial disruption. Exception: speech promoting illegal drug use does not require showing any disruption or credible threat of disruption. Personal student speech off campus. When the student's personal speech occurs off campus, it will be harder to censor. Schools will be limited to restricting speech to prevent cheating, bullying, threats, and other speech where pedagogical safety interests clearly outweigh the speech interests of students as private citizens. And school speech restrictions on speech related to the school's teaching, for example, speech by school faculty, to prevent, and by students as part of curricular or extracurricular activities, must be reasonably related to a legitimate pedagogical concern. Bunch of hypotheticals probably not answered. Speech in public employment. To write this down, because I feel like this is relevant. Could probably swallow all that stuff about teachers. Although you have private schools. I'm not sure that they're governed by all this, but maybe because the rights belong to the individual. Speech in public employment. Restraints on speech activities of government employees. Under the First Amendment, speech generally cannot be regulated or punished based on the content of the speech unless the regulation or punishment is necessary to achieve a compelling government interest. However, special rules apply when the government seeks to punish a government employee for speech or speech-related activities. Unprotected employee speech. If a government employee's speech while at work involves a matter of private concern, the employer can punish the employee if the speech was disruptive of the work environment. A government employer may also punish a public employee's speech whenever the speech is made on the job and pursuant to the employee's official duties, even if it touches on a matter of public concern. There is no First Amendment protection in either situation. If it's a private concern, or it's in the course of their duties, and it's thus official the employee statements while he's engaged in official duties. It's whether or not it's private concern or public concern. There is no First Amendment protection. Protected employee speech. If the speech is a matter of public concern but it is not made pursuant to the employee's official duties, the court will use a balancing test. The court must balance the value of the speech against the government's interest in the efficient operation of the workplace. For speech on matters of private concern outside of the workplace, the test is unclear, but the speech appears protected absent a detrimental effect on the workplace. Participation in political campaigns. The federal government may prohibit federal executive branch employees from taking an active part in political campaigns. Bans on receiving honoraria. A provision banning government employees from accepting an honorarium for making speeches, writing articles, making appearances was held to violate the First Amendment when applied to rank and file employees. Such a rule deters speech within a broad category of expression by a massive number of potential speakers and can also be justified only if the government can show that the employees and their potential audience's rights are outweighed by the necessary impact the speech would have on actual operation of the government. Patronage. And a public employee may not be hired, fired, promoted, transferred based on party affiliation or political views, except as policymaking positions where party affiliation and views are relevant. Loyalty oaths. A government can require employees to take loyalty oaths as long as the oaths aren't overbroad or vague. Overbreadth. An oath cannot prohibit membership in the Communist Party or require abstention from advocating overthrow of the government as an abstract doctrine. So there's a chart here on the punishment of regulations of employee speech. Was it within their official duties? If yes, the speech can be punished and regulated based on content, even if it touches a matter of public concern. If no, you ask, does the speech involve a matter of public concern? The speech can be punished or regulated only if the government's employer's interest in providing a efficient public service outweighs the employee's interest as a citizen in commenting on a matter of public concern. If it's not a matter of public concern, the speech is not protected by the First Amendment, the government may punish or regulate speech disruptive to the work environment. Oaths. An oath requiring public employees to support the Constitution and to oppose the unlawful overthrow of the government is valid, but an oath requiring public employees to support the flag is invalid. Disclosure of associations. The government may not force disclosure of every organizational membership or of affiliation in exchange for government employment or other benefit. It can only inquire into these activities that are relevant to the employment or benefits sought. Even here, however, a person can exercise their Fifth Amendment right to remain silent if the disclosure be incriminating. Overbreadth, vagueness, and prior restraints. Void for vagueness doctrine. If a criminal law or regulation fails to give persons reasonable notice of what is prohibited, for example, a ban on opprobrious and offensive words, opprobrious and offensive words, it may violate the Due Process Clause. The principle is applied more strictly when the First Amendment activity is involved. Overbroad regulation invalidation. Invalid. Regulation of speech or speech-related conduct will be invalidated as overbroad if it punishes substantially more speech than is necessary. Overbroad restrictions include a regulation outlawing all First Amendment activity in an airport terminal, a regulation prohibiting all canvassers from going onto private property, a private residential property to promote any cause without first obtaining a permit. Effective overbroad regulation. An overbroad regulation is facially invalid, that is, it may not be enforced against anyone, not even a person engaging in activity that is not constitutionally protected, unless the court has limited construction on the regulation so as to remove the threat to constitutionally protected expression. If the regulation is not substantially overbroad, it can be enforced against persons engaging in activities that are not constitutionally protected. Prior restraints. Prior restraints are court orders or administrative systems that prevent speech before it occurs rather than punish it afterward. For example, licensing systems and injunctions. They are not favored and are rarely allowed, especially if they're content-based. There isn't any special test for prior restraints. Content-based ones are subject to strict scrutiny, and content-neutral ones are subject to intermediate scrutiny. But the government's burden in justifying a prior restraint is heavy. For exam purposes, you should ask whether there is some special societal harm that justifies the restraint. Procedural safeguards. To be valid, a system for prior restraint must provide the following safeguards. The standards must be narrowly drawn, reasonable, and definite. The injunction must promptly be sought if the restraining body wishes to restrain the dissemination of certain speech, and there must be a prompt and final judicial determination of the validity of the restraint. For example, a review of a permit denial. A number of other cases, especially in the area of movie censorship, require the government bear the burden of proving that the speech involved is unprotected. These are your procedural safeguards for prior restraints. Narrowly drawn reasonable. I'm going to write these down, or I'll just screenshot it for now. Narrowly drawn, reasonable, and definite. The injunction must promptly be sought if the restraining body wishes to restrain the dissemination of certain speech, and there must be a prompt and final judicial determination of the validity of the restraint, for example, a review of a permit denial. A number of other cases, especially in the area of movie censorship, require that the government bear the burden of proving that the speech involved is unprotected. Cannot give officials unfettered discretion. As indicated above, a regulation cannot give officials broad discretion over speech issues. There must be defined standards for applying the law. Therefore, if the statute gives licensing officials unbridled discretion, it is void on its face, and speakers don't even need to apply for a permit. If a licensing statute includes standards discussed above, a speaker can't ignore the statute. They must seek a permit, and if it is denied, they can challenge the denial of First Amendment grounds. And so you've got valid and invalid prior restraints table. What's valid is prohibiting publishing of troop movements in times of war and enforcing contractual republication review of CIA agents' writings. What's invalid is prohibiting publication of the Pentagon Papers because it might have an effect on the Vietnam War, and prohibiting grand jury witnesses from ever disclosing testimony. Obscenity cases, you have seizures of books and films, you have movie censorship, and burden of government. Narrowly tailored to achieve a compelling interest is what's bolded here. When the government adopts a content-based prior restraint of speech, the government has the burden of proving this strict scrutiny standard, or that speech is unprotected, for example, obscenity. In movie censorship, the court has found that time delays incident to censorship are less burdensome on movies than on other forms of expression. So the court allows the government to establish censorship boards to screen movies before they are released, so long as the procedural safeguards discussed above are followed. And seizures of books and films may be made with a warrant based on probable cause, although if the item is available for sale to the public, a police officer may purchase a book or film to use as evidence without a warrant. Large-scale seizures must be preceded by a full-scale adversary hearing and a judicial determination of obscenity. Freedom of the press. No greater First Amendment. Generally, the press, along with corporations, unions, and expressive associations like lobbying groups, have no greater First Amendment freedom than does a private citizen, generally. However, they are treated just like any other individual speaker, thus the concepts already discussed apply. But you have some subsections here about publication of truthful information, subject to strict scrutiny if there's content-based restrictions on it, matters of public concern, that is, access to trials. The First Amendment guarantees the public and press a right to attend criminal and probably civil trials, but the right may be outweighed by an overriding interest stated in the trial judge's findings, for example, to protect children who are victims of sex offenses. The right includes the right to be present at voir dire and at other pretrial proceedings unless the judge makes specific findings that closure was narrowly tailored to preserve a higher value. Requiring press to testify before a grand jury. Members of the press may be required to testify before grand juries. What they ought to be saying here is whether or not that includes the source of their information. Although that's not always okay. I feel like that's privilege in some states and not others, and I don't know how it is on the federal level. Interviewing prisoners. The First Amendment doesn't give journalists the right to interview specific prisoners of their choice or to inspect prison grounds. Why? Reason being that they actually do defer to prisons and schools they provide some deference to limit the First Amendment rights of the press for safety reasons, of like keeping the community, the prison community, safe and not creating unsafe conditions that can arise when you introduce these types of interferences with regular prison operations. The same is true with schools. There's some deference given, and I'm thankful that there is, to like these institutions, because they know, and like we in the New York Times and government legislators don't necessarily know how to keep an effective ruling environment, as well as like principals and prison guards. So, business regulation or tax. I've heard about this. The press and broadcasting companies cannot be subject to general business regulations or taxes, like for ink and paper at one point in time, or postage, let's just say. I'm skipping this. Broadcasting regulations may be more closely regulated than the press. The government may protect its viewers and listeners from indecent speech over the airwaves because of the uniquely pervasive and accessible nature of broadcasting right can be available in someone's living room. That's an invasion, and at any given time to any audience. The government may also manage access and ownership of broadcast spectrums to promote the public interest in receiving information. So, fairness doctrine in First Amendment doesn't require broadcasters to accept political advertisements. However, a radio station may constitutionally be required to offer free broadcasting time to certain individuals, for example, opponents of political candidates, or views endorsed by the station, or persons who have been personally tagged in a broadcast. Because that's fair to address inaccuracies that may have been made during normal broadcasting. Internet and cable television regulation. Cable and internet regulations get strict scrutiny if they are content-based and intermediate scrutiny if they are content-neutral. Government speech and government-compelled speech. We have 11 more pages. Government speech cannot be challenged as violating the free speech clause of the First Amendment. The free speech clause restricts government regulation of private speech. It doesn't require the government to aid private speech or restrict the government from expressing its own views, absent some other constitutional limitation, such as the Establishment Clause or Equal Protection Clause. The government is generally free to voice its opinions. Likewise, the government can fund private speech that furthers its views while refusing to fund other private speech. Because government speech doesn't implicate the First Amendment, it isn't subject to the various levels of scrutiny that apply to government regulation of private speech. Generally, government speech and government funding of speech will be upheld if it is rationally related to a legitimate state interest. So that's the reasonable basis test. I'm going to put that for government speech. The president can express any political views that they want to express in the State of the Union address. A city could place a monument in a public park as a means of expression. Limitations, compelling private speech. The freedom to speak includes the freedom not to speak. Thus, the government generally can't require people to salute a flag or display other messages which they disagree. A person cannot be made to display the state motto, "Live free or die," on a license plate. Mandatory financial support. Although the government can't compel a person to express a message with which the person disagrees, the government may tax people and use the revenue to express the government message, even if the taxpayer disagrees with the message. For example, a beef producer can be required to pay an assessment that is used to support government-sponsored generic advertising of beef, even if the producer thinks generic advertising is a waste of money. However, people can't be compelled to subsidize private messages with which they disagree. For example, although lawyers may be compelled to pay bar dues, non-union members cannot be compelled to pay union dues because the money may be used to support political views with which the non-union members disagree. Exception, university activity fees. The government, and there are earlier cases read in this playlist, constitutional law playlist, that speaks to this. The government can require public university students to pay an activity fee A student activity fee, even if the fee is used to support political and ideological speech by student groups whose beliefs are offensive to the student, as long as the program is viewpoint neutral. Spending programs, I think they need to be open though to all students. Like it can't just have like a Catholic club that's just Catholics. But like there's lots of cases on it for expansion on these issues. Spending programs. A spending program may not impose conditions that limit First Amendment activities of fund recipients outside the scope of the spending program itself. For example, the government can't require recipients of federal funds given to organizations to combat HIV and AIDS to agree in their funding documents that they oppose prostitution. Government funding of private speech. When the government chooses to fund private messages, for example, college group newsletters, it generally must do so on a viewpoint neutral basis. Exception. Funding of the arts. From a financial standpoint, the government can't fund all artists, and choosing which it will fund inevitably may be based on the contents of the art. Limitation. Not all speech activity on government property is government speech. Determining whether speech, particularly speech that occurs on government property, is government speech requires a holistic approach. While this view is context-driven and not mechanical, some factors that may be relevant include the history of the expression at issue, the public's likely perception as to who, government or private person, is speaking, and the extent to which the government has shaped the message. Example, I don't even know when to use this test. Not all speech activity on government property is government speech. Determining whether the speech particularly, let's just give the example. When a city did not exercise meaningful control over the flags flown on a particular flagpole outside City Hall, did not shape the messages the flag sent, and had previously granted all flag raising requests without exception. The flags were private, not government speech, and the flagpole was a designated public forum. Therefore, denying a group permission to fly what the group described as a Christian flag constituted viewpoint discrimination in violation of the First Amendment. So again, the history of the expression at issue, the public's likely perception as to who, government or private person is speaking, and the extent to which the government has shaped the message. Now you have trademark protection and freedom of association, the electoral process, limits on contribution, expenditures, regulations on core political speech. There's a table about what's valid electoral regulations versus invalid. And then we get to freedom of speech, which is 1, 2, 3, 4, 5, 6, 7 pages long. So I'm going to read something else for that. I'm going to read electoral regulations for that. Contributions. I'm just reading here that there's limits to them are subject to intermediate scrutiny to prevent corruption or the appearance of corruption. Laws may limit the amount of money a person or group or corporation can contribute to a political candidate, but may not limit the amount of money that may be spent to support or oppose a ballot referendum. Aggregate contribution limits are unconstitutional, i.e., the government cannot limit the aggregate amount one person or entity contributes to political candidates or committees during an election, even though it can limit the amount given to a single candidate. Aggregate limits violate the First Amendment protection of political speech because, unlike individual contribution limits, they do not further the government's interest in preventing quid pro quo corruption or the appearance of such, and they seriously restrict the participation in the democratic process. Limits on expenditures, like for a candidate, may not be limited, as long as the expenditures are not contributed directly to the candidate nor coordinated with those of the candidate. So they must be independent of the candidate, not disguised contributions. Compare regulations of core political speech, for example, electioneering, distributing campaign literature, rather than regulation of the process surrounding the regulation will be upheld only if it satisfies strict scrutiny. Under the standard, a state may ban personal solicitation of campaign funds by judicial candidates because such a ban advances the state's compelling interest in preserving public confidence in the integrity of the judiciary. An ad concerning a political issue will be considered protected core political speech unless it's susceptible of no reasonable interpretation other than one as an appeal to vote or against a particular candidate. So what's valid electoral regulations? Requiring reasonable number of signatures to get on a ballot, enforcing a party rule, requiring a voter to be registered with a political party to vote in the party's primary. That is valid. The states can't limit that. I think I now understand what was said here. Requiring a voter to be registered in a political party as an independent to vote in the party's primary. For example, prohibiting persons registered in one major political party from voting in the other party's primary, and allowing political parties to choose nominees for state judgeships at state conventions, prohibiting campaign activity within 100 feet of the polling place. Is narrowly tailored on election day because it involves core political speech, prohibiting individuals from appearing on the ballot as a candidate of more than one party, prohibiting personal solicitation of campaign funds by judicial candidates. What's invalid? Prohibiting party from endorsing or opposing candidates in the primary, regulating party selections of delegates to national convention, prohibiting any campaigning on election day, which involves core political speech and is overbroad, requiring political parties to allow non-party members to vote in the party's primary elections. This is just so fine. I don't think I'm going to be able to remember this. Increasing contribution limits for a candidate whose wealthy opponent achieves an advantage by spending a lot of its own money on the campaign. That's invalid. To increase contributions just because you're seeing wealthy candidates like Osmond or whatever the heck his name is. Umit Oz. Prohibiting judicial candidates from announcing their views on disputed legal and political issues. So I read all that about the electoral process. With laws regulating elections may impact the First Amendment freedom of speech, assembly, and association, the court uses a balancing test to determine whether regulation of an electoral process is valid. If the restriction on First Amendment activity is severe, it must be narrowly tailored to achieve a compelling interest that is strict scrutiny. But if the restriction is reasonable and non-discriminatory, it will generally be upheld. Freedom of association. Although the freedom of association is not mentioned explicitly in the Constitution, it's clearly implied from the rights that are explicitly noted. Pursuant to this freedom, the government may neither prohibit politically unpopular groups nor unduly burden the person's right to belong to such groups. If the right to association is substantially burdened by a content-based regulation, strict scrutiny is triggered. But in content-neutral regulation that incidentally burdens association is only subject to intermediate scrutiny. So this would be your content-neutral association. Association what? Regulation. Okay, trademark protection is not government speech, but rather is private speech. Thus, content-based restrictions on trademarks are subject to strict scrutiny. Content-based restrictions on trademarks. I'm also going to put here prior restraints. I should really even add as much as I can to this little table I've got going on the back of my notebook. But anyhow, let's keep going. We're practically done. The next thing is freedom of religion, and I'm not trying to shortchange it, but there's the free exercise and there's the establishment clause. Free exercise clause prohibits government from punishing someone on the basis of their religious belief or related religious status or conduct. I might write that down. All right, because that's a good definition. What constitutes a religious belief? There's one answer, and they ask it a lot, or at least they ask around it to get to it. It's sincerely held, I think. I think that's what constitutes a religious belief. Sincerity versus whatever. Sincerely held. Sincerely a person's belief. Now, discriminatory law subject to strict scrutiny is a law or other government conduct that discriminates on the basis of religion is subject to strict scrutiny. The law is discriminatory if it is either not neutral on its face, that the law expressly provides favor to disfavor treatment based on a religious belief, conduct, or status, or facially neutral but not generally applicable. That is, the law is silent with regard to religion, but by design it targets religion generally or religion in particular. So I'm going to write discriminatory laws here. On the basis of religion. And that means not neutral or by design. Not generally applicable. What do we mean when we say that? Neutral laws of general applicability. Right? What are they subject to? Unless it was specifically designed to interfere with religion. Basically, neutral laws of general applicability are not subject to the free exercise clause. Which I guess mean that it's not subject to strict scrutiny. But it doesn't say that. So laws with a system of exemptions are not generally applicable. You get an idea. They're talking about government officials' discretion to grant exemptions from the law. So religious exemptions are subject to strict scrutiny. Why? Probably because of the next section we're going to get into. There's a couple exceptions here for ministers and unemployment compensation cases, the right of the Amish not to educate their children, federal outside the scope. Okay, the Religious Freedom Restoration Act allows a person to challenge federal laws of general applicability as burdening their religious beliefs and practices, and the strict scrutiny is applied in actions brought under the act. However, the Religious Freedom Restoration Act is statutory in nature and is outside the scope of constitutional law questions. Here's the definition of the Establishment Clause. The Establishment Clause prohibits government sponsorship of religion, meaning the government cannot aid or formally establish a religion. Like the Free Exercise Clause, it compels the government to pursue a course of neutrality towards religion. The key concepts is the neutrality principle, that coercion is prohibited, and the history and traditional approach. Oh, I forgot about the approaches. The types of cases that you see are sect preferences. Favoritism is not necessary to achieve a compelling interest. So government action that prefers one religion sect over another violates the Establishment Clause, at least if such favoritism is not necessary for any compelling purpose. So cases unconnected to financial aid or education, cases involving financial benefits to religious institutions, recipient-based aid to schools, high schools. None of it violates the Establishment Clause. For treating religious private schools the same as non-religious private schools. religious activities in private schools. So I don't know why they like don't give us the lemon test, but the lemon test is how to look at this. So there's a couple things that I'm just going to say about here it is, religious freedom of religion. The exercise clause, some things to remember, especially testing MBE, is that there's no punishment for beliefs. There's total freedom to believe as desired. The conduct cannot be punished solely because it's religious. The general conduct regulation that incidentally burdens religious practice is generally valid. Religious exemptions for religious belief generally are not required except, and we talked about them already. Establishment clause, the government action and law respecting the establishment of religion is valid if it has a secular purpose, it has its primary effect neither advances nor prohibits religion, and it does not cause excessive entanglement between government and religion. That's the Lemon Law. Here's what you'll see is prayer in public schools is generally prohibited. Invocation prayer at legislative sessions and town hall meetings generally is valid because it recognizes a long history of prayer in America, and adults are not of tender impressionable years as they are in schools. Religious symbols at Christmas time displays valid if accompanied by non-religious symbols, recognizes historic roots of American Christmas holiday, and displays of 10 Commandments on public property invalid if shown to have a predominantly religious purpose. So that's all I'm going to say about freedom of religion right now. Actually, that's it.